Durbin.
Thanks, Mr. Chairman, for holding this hearing. In less than 3 months, 702 will expire. As a committee with jurisdiction over FISA, we have a responsibility to conduct oversight and to craft solutions that protect security and the constitutional rights of Americans. Given this responsibility, I am disappointed that we do not have any witness from the Trump administration testifying today. Members of this committee should be allowed to publicly question executive branch officials regarding their use of this sweeping authority, especially for warrantless surveillance of Americans. That's why when I served as chairman of this same committee, I convened a hearing with senior officials from the Biden administration so that they could be interrogated publicly and the public could hear their answers. The failure of the Trump administration to appear before this committee on important issues is a troubling pattern that must come to an end. For months, I've been calling on Secretary Noem to answer for the lawless and inhumane reign of terror her agency has unleashed on America. Secretary Noem had such a busy schedule that she was unable to come before this committee in the last calendar year. But now, she said she might find time in her schedule to join us in a mere 5 weeks. What's going to happen in Minneapolis in the next 5 weeks? When you look at the past 5, it's a legitimate question. With the Trump administration challenging our constitutional rights and the sunset of Section 702 just 3 months away, a hearing with government officials to address the use of surveillance is imperative. Section 702 grew out of a secret, warrantless surveillance program under the Bush administration. When this illegal program was exposed, Congress responded by authorizing a new authority known as Section 702. It allows the government to collect communications of foreigners located abroad without a warrant or court order for the purpose of collecting foreign intelligence. There is no doubt that Section 702 is valuable. However, for years, the government has used it as a domestic spying tool to collect millions, maybe billions of Americans' private communications. And it's in searching these vast troves of these communications, reading our text messages and emails, and listening to our phone calls, all without a warrant required by the Fourth Amendment. Section 702 has been abused to spy on business and religious leaders, political parties, members of Congress, campaign donors, journalists, and political protesters of all stripes. In passing the Reform Intelligence and Securing America Act in April 2024, Congress codified modest measures to reduce these abuses. But RISA also weakened other safeguards and greatly expanded the scope of 702. It is my view, when 702 was authorized in 2008, and it remains my view now, that this section does not contain sufficient safeguards to protect the privacy and civil liberties of Americans. That is why, since the first reauthorization of FISA in 2012, I've worked on a bipartisan basis with Senator Lee, and we continue to work together to require a warrant for the search of any American communications. I urge my colleagues to join our effort. I look forward to working with the chairman to ensure that Congress does not fail the American people.
Would you like to introduce your person?
Thank you. Chairman has asked me to introduce the minority witness, and I'm sorry I have to leave after I do that. But it's my pleasure to introduce the minority witness, Liza Goitin. Liza, I hope I pronounced your name correctly. Is that close? Okay. Ms. Goitin is Senior Director of the Brennan Center for Justice, Liberty, and National Security. She seeks to advance effective national security policies respecting constitutional values and the rule of law, nationally recognized expert on presidential emergency powers and government surveillance and secrecy. Testified before this committee before. She served as counsel to this committee's Constitution Subcommittee and a trial attorney in the Justice Department. Graduate of Yale Law School and a clerk in the U.S. Court of Appeals for the Ninth Circuit. Welcome back.
Thank you, Senator Durbin, and welcome, Professor Goteen. I'd like to introduce Mr. Stuart Baker. Mr. Baker has extensive experience in government and the private sector, including as a law clerk to U.S. Supreme Court Justice John Paul Stevens. Mr. Baker also served as general counsel to the National Security Agency from 1992 to 94, and later as first assistant secretary for policy at the Department of Homeland Security. Mr. Baker testified before the September 11th Commission on Intelligence and Law Enforcement Issues. His expertise in this area makes him particularly qualified to testify here today. And then Professor Adam Klein is a subject matter expert on counterterrorism, intelligence, and government surveillance. He currently serves as the director of the Robert Strauss Center for International Security and Law at the University of Texas. Mr. Klein previously served as chairman of the United States Privacy and Civil Liberties Oversight Board, where he conducted oversight of the intelligence community, including Section 702. Mr. Klein served as a law clerk to U.S. Supreme Court Justice Scalia and Judge Brent Kavanaugh when Kavanaugh was still on the D.C. Circuit. His legal and policy expertise are a nice asset to this discussion. Before you testify, I would like to make a comment that would follow up on the administration not being here to testify. Congress is an Article I branch of government. This essential program is set to expire in just a few months, and it's our job to reauthorize it. Today, we're hearing from experts with diverse views and experience, including government experience directly relevant to the program. For my part, I'm offering legislation and holding this hearing. Congress set the reauthorization clock the last time it passed in 2024, and we need to meet our own timeline. If the administration would like to brief us in an open or closed setting.
What you just watched is more than a routine Senate hearing moment. It's a window into a deeper constitutional clash that's been building for years. And Senator Dick Durbin is using this moment to draw attention to something that often gets lost in the daily political noise. Who holds power when it comes to surveillance, immigration enforcement, and executive accountability? And what happens when that power goes largely unchecked? Durbin's remarks sit at the intersection of two major issues. First is the looming expiration of Section 702 of the Foreign Intelligence Surveillance Act, one of the most powerful surveillance tools the federal government has. Second is the broader question of whether executive branch officials, especially in a polarized era, can avoid public scrutiny by simply declining to testify before Congress. The controversy has always centered on what happens next. Once those communications are in government databases, agencies can search them. Durbin and a bipartisan group of civil liberties advocates argue that when those searches involve Americans' communications, they should require a warrant under the Fourth Amendment. Without that safeguard, they say, Section 702 becomes a backdoor domestic surveillance tool. The next few months will matter. If Section 702 is reauthorized without major reforms, critics will argue that privacy protections remain too weak. If it's allowed to lapse or significantly restricted, intelligence officials will warn about gaps in national security. And if executive officials continue to avoid public hearings, you'll likely see more calls for subpoenas and more public clashes between Congress and the administration. At the same time, Durbin ties the surveillance debate to immigration enforcement and the Department of Homeland Security's actions in major cities. He uses strong language to describe enforcement operations, arguing they've targeted communities broadly rather than focusing narrowly on individuals with criminal records. This is a classic democratic framing, emphasizing civil liberties, due process, and the risk of overreach. There's also a deeper constitutional lesson here. The U.S. government is built on separation of powers. Congress writes the laws, the executive enforces them, and the courts interpret them. Oversight hearings are one of the main ways Congress keeps the executive branch accountable. When those hearings don't include administration witnesses, lawmakers often see it as a sign that the balance of power is shifting too far toward the executive.